session is about estate planning and about how you can write the perfect will and how will can be an effective tool for your succession planning. In old Bollywood movies, we see somebody writes a will, then it gets disputed, and there is a whole drama around it. So how does one write a will? Why is it important? Is adding nominees in your demat account or bank accounts, is that enough? Take us through that.
Sure. Firstly, thank you for inviting me for this session today. I was there since around 3 o'clock-ish or so, and some of the stuff I heard earlier about wealth creation, and so if you do all the things right, which these previous speakers spoke about, you can make a fabulous amount of wealth. So I think it's just putting it in context that you're working hard, you're investing well, you're running a business sometimes, and creating all this wealth. You need to be very careful about how you want to pass on that wealth also. As we've seen across the history of corporate India, in case you don't make a will or you make a will which doesn't go as you plan, I mean that wealth can just go in an instant. So I think to put it in context, I think in the last 5, 6, 7, 8 years, I think especially post-COVID, I think a lot of individuals, a lot of wealth creators, especially business owners, are spending a lot of time in putting their, I would say, broader succession plan in place, out of which I would say an important but not the only component is how they write the will. Just to give you some context about what happens in case you don't make a will, you literally just drop dead as you speak right now, and the answer differs by what religion you follow. If you're a male, if you're a female, so there's quite a variety of things that can happen depending on who exactly you are. To give you the kind of context of what happens to a Hindu male in case that person dies without a will, it will go equally to that person's mother, to that person's spouse, the widow, and to the 2 children equally. So in case you don't want this to happen, you want it to go to your children only, you want it to go to, a charity, you want it to go to your, trust, etc., then you need to have a will to make sure your assets go exactly where you intend it to be. So I think in case like the introduction was saying earlier, in case you want to pass it on exactly how you wish, I think make a will. But I think we'll chat about it further. I think you can do some stuff in your life as well to control the destination of it.
What about, is adding nominees good enough or you still need a will?
Good question. I kind of get that question a lot. I think it's just good to just take a step back and just be clear what exactly a nominee does. I mean, there's been judgment after judgment after judgment of the Supreme Court setting out, as per law, what happens to a nominee. Contrary to popular belief and understanding, a nominee does not convey title, does not, do succession for you. In India, there are only 2 ways you can die. With a will, without a will. There is no third form of succession which involves a nomination. So what a nomination does, if I nominate you for my mutual funds, debt, whatever, but in my will I put my 2 daughters as inheritors, what that means is that you are the temporary custodian of that property and it belongs under law to my daughters. So in case you spend the money, like somebody said, buy a Lamborghini or something, you are accountable in law to my daughters for that, misuse of that nomination. So to be clear, what it only means is that it's more a release for the bank or the mutual fund or the insurance company that we release you from the obligation to take any further action, but it belongs in law to what the law says under succession.
So legally speaking, nominee is a custodian sort of.
Nominee sits below a inheritor as per the will.
Yeah, can you take us through, the nitty-gritties of writing a will? What are the technicalities? If you can break it down for our audience.
The beauty of a will compared to all the other stuff you can do in law is like literally the most simplest document you can make. You just need 3 things. A, has to be in writing. So, and writing can be typed also. Writing can be by your hand also. A, has to be in writing. B, it has to be signed by you. And signed physically, not e-signatures and virtual signature, all that stuff. Signed, and 2 witnesses. That's it. There is no nonsense of stamp paper, green paper, notarization. All that is completely irrelevant. Will is just in writing, signed, 2 witnesses, done. As simple as it is.
Right. But to make sure that it is, legally robust, should one do something else? I mean, another layer of due diligence is that needed?
Yeah. So I think that perfectness, as you said, to make the perfect will, as the session is called, I think that is where the art and the science of, will writing really comes in. You can make a will online for $1,500 for some of these online platforms, etc. But I think as you get wealthier, as you have, larger families, as you have more complex families, in case you have, especially a business, I think the requirement to, really customize your will and, be very clear how you want it to go is very important. Without going into too much micro detail, I think couple of key steps in it. One is kind of how detailed or how light or, or how khoka you want it to be. We have seen wills which are just simply half a page saying that all my property goes to my daughters, full stop. I mean, then it's up to the executor when the time comes to inventarize your estate, list it out, make a valuation, make a judgment call about how to split the estate, etc. So that's a simple, but I think a lazy and maybe even a bad option. What we are kind of seeing families do well, I think, is kind of make it a bit more detailed, item by item, by line item, take valuations when the property is being sort of, being considered for succession, and be a bit more thorough, I think, per asset class or per asset, not even asset class, how they want it to go. How will each folio of investment go to the family member or whoever?
And register it also.
Registration also, we've done like hundreds and hundreds of these, out of which I would say not more than 10 to 8% have been registered. What it kind of means in law is that registration only means the person who's made the will has actually signed it. So there's no question of forgery or somebody, misusing or creating a fake will. But it doesn't affect the contents of the will. If I make a will to register it and say I give the Taj Mahal to you, doesn't mean I have title on the Taj Mahal to pass on to you. So it only means that I've actually made the will, full stop. Whether I was sound mind is a different question. How can I bequeath the Taj Mahal to you? So it's about the context of which registration really falls under.
And, should youngsters also think about a will?
Yeah, definitely. During the COVID times, we made wills for people who were 21, 22 also. We're still doing lots of these today. I think, as a lot of looking around, a lot of, young investors here, people who are studying, people in college, etc. If you're above 18, you can make a will under law. It's as simple as that. And I think it would be, like I said, in case you want the property to go where you intend it to go, it's really important you to actually think about making a will. And I think also the question is that how often should you revise or kind of update your will? We kind of see it as you update your portfolio when the market changes, something happens, good or bad in the economy, you update your will, update your portfolio. Same thing has to happen for your will as well. People are born, people die, your net worth grows, your net worth goes down. You may want to change your citizenship. You may want to have, your family grow and, having, cross-border assets, etc. So at each, I would say, major life event that you have, you're required to, not required to, is good practice to update your will. Take into account those circumstances.
So I'll open it for questions.
Yeah, sure.
Any questions in the audience? Yeah. Can you have a mic?
Maybe one thing I'll just add to maybe set the context for the audience also. You said about the best practice in a will. I think the most important thing to do under a will is pick your executors carefully. They are the people, when you're long gone, you're sort of not in this world anymore, who give life to your will. How it comes into practice, how the assets go to your loved ones, could go to your family, could go to somebody else. So there I would say the most important choice you have to make under your will.
Good evening, sir. My name is Jindesh. I have a question. Is it mandatory to update your will? Is there some specific time when we have to update your will every time?
Yeah, sure. I think I was just speaking on that right now. But I think there's no hard and fast rule. We have some clients who come to us every 5 to 7 years and say, okay, my portfolio has increased by so and so. I have so many new investments, so many new companies, etc. So updating the will. But if you're happy with having, for example, a more general will talks about all my assets as per the date of my death, that's good enough. You don't need to keep updating a will at that point of time. So I would say if your will is very specific, then keep updating it. If it's more general, then you can live with it forever.
Thank you, sir.
That lady has a question.
You mentioned that nominees are only caretakers or custodians till the will is executed.
Correct.
But in my experience, on a death, the mutual fund units and shares are transferred to the nominee's account.
Correct.
And the
Correct.
brokers do not agree otherwise.
Yeah.
So in that case, how does the beneficiary of the will enact it? And aren't there taxes applicable because the nominee and the beneficiary might not be related?
Yeah, correct. So actually it's a very live issue and a lot of families kind of go through this problem. The problem comes when your nominee does not align with what your will says who the owner of the property is going to be. A lot of people put child A as nominee, but child B gets a property under the will, mutual funds or, bank account, demat accounts, etc. So there's been a lot of problems across different regulators in this. There's a great report which came out about 2 months ago by the Money Life Foundation by Sucheta Dalal and Justice Gautam Patel, which looked at how nominations work and the problems across, across different asset classes. And it is more or less a royal mess. Every regulator has their own, SOPs and practice. The banks have their own, internal rules on top of that as well. So I have my own internal ranking of which banks are good, which banks are bad. We get the bad bank, God help you. But this could take a very long time. It requires some very uncomfortable conversations with the other legal heirs as well to get NOCs, release deeds, etc. In case you're an NRI sitting outside asking a bank in India to transfer mutual funds to you, that's another whole ball game by itself. So I think the choice the family should make is when they make the will itself, put the nominee and the owner as the same person. That takes care of half the problem, I think. Hopefully that answers your question.
Yes, thank you.
Okay, we have a person there. Okay, we have someone here also. So there's so many. I'll come to you. I'll come to you.
Yeah, hi. Hi, my name is Gautam Karamchandani. I have a question. I'm a businessman and I own some real estate. I own some financial assets and many other investments, right? So when it comes to making my will and to make sure that, it goes down properly to my children, I have 2 kids. What is the correct way to actually distribute wealth equally to them, where when they inherit that there is no confusion between them? I would actually like to give it to them equally. But there is real estate involved which can go up and down in value. So suppose if I give one kid a particular real estate and another real estate property, I just want to make sure that they feel well treated and that there was no disparity. So I want to understand from you, is there a solution to this?
Yeah, it's a good question. Josh and I were talking about this. Should we touch upon what certain business families are doing to take care of, exactly what you're saying right now? My funda in life is that from a succession planning perspective, I think the will is the worst thing you can do for your estate planning. Because it happens very, very late in your life. You make a will today in your 30s, 40s, whatever. You die when you're 90. There is no succession planning happen during that intervening time. Relationships change, people change, requirements change, etc. It's too long delayed in the process to have an effective succession plan. And the other choice is giving something immediately right now as well. Like you mentioned, a house over there. Do you want your house sitting in somebody else's name? Do you have that comfort that roof overhead will continue in case relationships change and somebody evicts you? That's a very real risk in today's world. So I think what a lot of families are doing, especially for real estate assets and for some businesses as well, transferring into a trust in the life of that person itself. You could have multiple trusts, one per child. It could be a shared trust with different portfolios for each child, 50-50, 60-40, whatever the proportion may be. And that is good because, A, the transfer happens in your life itself. You can control the trust. You can see, who gets what distributions happen. In case the property is a commercial property getting, rental income every year, you can allocate the income to the, cash flow requirements of the family, etc. So to kind of answer your question, if you want perfect clarity, succession will happen. A, do it in your life. B, a trust is not a bad option in this situation. And don't rely only on the will for something so important here.
That's a great point. Yeah, can you please pass the mic to him? He's waiting. Okay, you can ask. Meanwhile, you can ask.
Hello. I was told that the Insurance Amendment Act 2015 had changed the definition, that they said nominees equal to beneficiary. Is that correct?
Yeah, so there was an amendment for beneficial nominee only for insurance specifically, not for any other regulation.
Yes.
So in case your nominee is, I think, your parents, spouse and child, it goes to them full outright as per law. In case anybody else, and what I said applies, only a temporary custodian until the property goes as per the applicable succession law. But it's only for life insurance.
Yeah, so for life insurance, the nominee is the beneficiary.
Yes, only with certain types of beneficiary, not everybody. Thank you.
Okay, you can ask.
Hi, Ajay Mehta here. I would like to know when
Speak a little louder.
Yeah, when is a probate required?
Yeah, that's where the fun happens. Our own firm was born out of a probate, so I'll come to that if we have time. Probate applies in very, very limited circumstances. It applies in two circumstances. A, when the will itself is signed in the city limits of Bombay, Madras, and Calcutta, only these three cities, nowhere else. And three, or the second option rather, is when there is physical property in these three cities, Bombay, Madras, and Calcutta. Nowhere else in India is probate compulsory. And what probate means for the benefit of the audience is that in these three cities or these circumstances, when a will is made and when the person passes away, the will doesn't automatically come into existence at that point of time. You have to go through a process in the Bombay High Court, or Calcutta High Court, or Madras High Court, where you file a copy of the will with the court. The court verifies the genuineness of the will. There is no forgery, there is no undue influence, there is no coercion, there is no kind of foul play going on there. And only once that process is complete, then the title is conveyed to the legatee. The very, very high risk in that is the way the process works is that when the will first goes to the court, a legal notice goes from the court to all the beneficiaries, all the people mentioned as per class 1S, so to all the children, the spouses, etc., saying that, this person has made a will, this is what the will says, any objection whatsoever. The problem is in case somebody files an objection, they have a disagreement with how the will is written, there's a family fight or something going on, it converts into a civil suit. Then you have your tariq pe tariq situations, as you mentioned earlier, then you're kind of stuck in 20, 30, 40 years of litigation. What could have been a simple, 12 to 15 month probate becomes a 30-year case, which is why I think I was discussing earlier, a will is the most dangerous thing you can have from a succession planning perspective. Great example you can see in the public domain is happening live as we speak today. The Oberoi family, Oberoi Hotel family, exactly this is going on. 2 wills have come up, probate challenges on in the Delhi High Court right now. And second example, Birla Lodha, Calcutta High Court. Exactly the same fact pattern, filed in 2004. It is still being disputed today, almost 20 years later. 5,000 crores at that point of time. Today, I don't know what the value is, but the Birla Group is run by the Calcutta High Court today for exactly the reasons I just laid out.
Great.
I just have one more question. I've been waiting for a very long time. If I can just say my question. This is a follow-up to the trust thing that you mentioned. It is usually considered that trusts are for super wealthy families. What is your take on that? Or what kind of, a base threshold of assets can we look at? And what could be the basic costs of setting up such trust and some ongoing costs? If you can share some light on that, especially in today's scenario when there's such disposable income available, even with a middle class and an upper middle class. So how do they transfer assets via trusts and things like that?
I think that question requires another mint conclave just by itself. But in terms of the kinds of people we see using trust today, I would begin into 2 broad categories. One is business families, especially when you're in the SME mid kind of range over there, where you have multiple family members, you have a business of, let's say, discussion purposes, 200, 300 crore kind of, net worth plus. So you have that scale, the business is growing, family members involved in the business, shareholding could have been fragmented. So to kind of consolidate the whole thing into one structure, trusts are being used for that. And the other category I see is more kind of professional investors. You set up trust, a lot of private equity owners, a lot of, large personal investors like the kind we kind of heard today speaking earlier. So they want a consolidated pool for investment. So by whatever name called a family office. So as opposed to your portfolio sitting in your personal name, which, the probate risk, which I mentioned, could apply to you, something could go wrong for your, family. So to kind of lock in the money and just make sure that nothing external can, damage your portfolio, trusts are being used for that circumstance. It's not for everybody. I think, the setup cost is high. There are legal fees. There could be stamp duty transfers. If you got a professional trustee, you could be paying professional trustee fees as well. Typically, it is 0.1% of the asset or something around that range. Ongoing fees on a yearly basis. So I would say if you got a large liquid pool, it makes sense. If you're a new investor or a retail investor, I think it's too early in the game for a trust.
One small, basic, simple question, if you don't mind. I know that in a will, one needs to mention that one is of sound mind. So does one also need to have a medical certificate attached to that?
Very, very good point. Definitely, yes. As best practice, I would say that I mentioned you need 2 witnesses. In all the wills I've done, I've been one witness, a doctor has been the other witness, with a medical certificate saying on the day that the will is signed, that person was of sound mind and body. So yes, definitely.